The question is, Eric owns a waxworks museum in the seaside town of Westsea. He decides to have a new air conditioning system installed in the museum by Occupier plc, but Occupier can only carry out this work at the height of the tourist season, rather than delay the job until winter, or shut down while the work is being done and lose income. Eric decides to allow the public into the museum while the new air conditioning system is being installed. He places notices around the museum stating danger, work in progress, while the employees of Occupier are working in one part of the museum. Some scaffolding that they have erected in another part of the museum collapses. The scaffolding injures Florence, who paid to enter the museum, and George, who entered without paying through the open back doorway that Ocupier's employees were using to bring in equipment. Now you have to advise Florence, who has suffered a fractured skull and had her spectacles broken, and George, who has suffered a broken shoulder and has had his new suit how to answer this question. In this regard, the following points need to be discussed. Firstly, the status of Eric and Occupier both being occupiers. Secondly, Eric's duty to Florence and the application of Section 2, subsection 4, paragraph B, of the Occupiers Liability Act 1957. Thirdly, the liability of an occupier to a non-visitor like George under the Occupiers Liability Act 1984. Fourthly, the type of harm that is recoverable. For answer to this question we should note that Eric is the occupier of the museum as he has sufficient control over the premises. Wheat vs. Lucan, 1966. In addition, Occupier may also be an occupier of the museum, for there is no need for control to be exclusive. Wheat. The museum satisfies being a premises under Section 1(3) of the Occupiers Liability Act 1957. The question is whether Occupier, as an independent contractor, has sufficient control, as in AMF International vs. Magnet Bowling, 1968. This is, of course, a question of fact and, as presumably the installation of an air conditioning system in a waxworks museum would involve extensive work, Occupier may well be held to be an occupier and so also be liable together with Eric. As far as claim of Florence is concerned, the answer should be as follows. Florence is Eric's visitor. Eric owes Florence the common duty of care by Section 2(1) of the Occupiers Liability Act 1957. By Section 2(2), the duty is to take such care as in all of the circumstances of the case to see that the visitor will be reasonably safe in using the premises for the purposes for which he is invited. It should be noted that it is the visitor who must be reasonably safe and not the premises, so the fact that renovations are taking place does not, by itself, constitute a breach of duty. See, for example, Ferguson vs. Welsh, 1987. The question as to whether the occupier is in breach of his duty is always a question of fact depending on the exact circumstances of the case. Eric will, however, seek to rely on the defense contained in Section 2(4)(b) of the 1957 Act. This section states the occupier will not be liable for the work of an independent contractor where the occupier had acted reasonably in entrusting the work to an independent contractor and had taken such reasonable steps to satisfy himself that the contractor was competent and that the work. There is nothing in the facts of the problem to suggest that Occupier is anything but competent. The question, therefore, is what, if any, steps Eric ought reasonably to have taken to satisfy himself that the work had been properly done. Despite the words had been properly done in the subsection, it was held in Ferguson vs. Welsh, 1987, that the obligation could arise where the work was still being done and had not been completed. The rule is that the more technical the work, the less reasonable it is to require the occupier to check the work. Cf. Haseldine v. Dorr, 1941. And Woodward vs. the Mayor of Hastings, 1945. The work of installing an air conditioning system is certainly technical, but we are told that the damage was caused by scaffolding collapsing. If this danger was obvious to a reasonable observer, Eric should have been aware of the danger and cannot bring himself within Section 2(4)(b). However, if the careless work of Occupier was not apparent upon such examination, Eric will not be in breach. Next, we need to consider whether the notices stating danger, work in progress discharge any duty owed by the occupier. By Section 2(4) of the 1957 Act, where damage is not to be treated without more as absolving the occupier from liability, unless in all of cause to a visitor by a danger of which he has been warned by the occupier, the warning, the circumstances, it was enough to enable the visitor to be reasonably safe. Work in progress here does not indicate the nature of the danger, and it is a question of fact whether this is adequate in allowing a visitor to be reasonably safe. In Ray vs. Mars UK, 1989, it was held that where an unusual danger exists, the visitor should not only be warned, but a barrier or additional notice should also be placed to show the immediacy of the danger. On the facts of the present case, this had not been done. As the scaffolding fell on Florence, it seems that, in addition to the notice, the area should have been roped off to keep visitors away from any possible danger. Hence, the advice to Florence is that Eric may be able to avail himself of this statutory defense, so she would be better advised to sue Kulit under the Occupiers Liability Act 1957 as occupiers and/or in negligence. Florence can recover for both the injury to her person and the damage to her property. Section 1(3)(b) For the claim of George, we have to see that George is clearly not a lawful visitor of Eric or Kulit. The duty owed to George is covered by Section 1(3) Occupiers Liability Act 1984. In George's case, Requirement A is satisfied as Eric was aware of the danger, as can be shown by his placing of the warning notices. Woolens vs. British Celanese, 1966. Rind vs. Astbury Water Park Limited, 2004. Cohen vs. Coventry Healthcare NHS Trust, 2006. However, Requirement B is not satisfied, as Eric has no reason to anticipate George's presence is or could be in the vicinity of danger. In both Donegal vs. Folkestone Properties Limited, 2003, and Tomlinson vs. Kingleton Borough Council, 2003, the position of trespassers was considered, and it was held in both cases that there was no duty owed in respect of obvious dangers, and that no duty was owed where persons freely and voluntarily undertook an activity that involved some risk. See the High Court decision in Andrew Risk vs. Bruford College, 2013, as a recent application. In George's case, it could be argued that the danger from the activity involving scaffolding is obvious, and that using the back door to enter the premises involved an element of risk in that any warnings would not be apparent to George. Either way, the question to then be determined is whether it was reasonable to take precautions to protect against the risk. This is a similar judgment to what is found in Section 1(4), and it is argued here that it would be reasonable to protect against unsafe scaffolding for the potential seriousness that such harm could do. Even if the duty does arise, it can be discharged by a reasonable warning. Section 1(5), but see the discussion above. By Section 1(9), injury only includes personal injury, and damage to property liability under the 1984 Act. The damage to his suit would be irrecoverable. UT is expressly excluded. Section 1(8). Thus, in the unlikely event of George being able to establish liability under the 1984 Act, the damage to his